Hi, this is foreclosure defense attorney Roy Oppenheim. I want to talk just a little bit about a law review article that is being published by the Stetson Law Review that was written by my associate Jacqueline Trask and myself, as well as contributed by Jeff Sherman and others in this office. And we talk about the history of the securitization process and why it's kind of like black magic. And what's really interesting is that while the article has yet to be released, it has in a peculiar way gone viral. And the question is, why would a law review, in usually a staid publication, have an article that goes viral? And the issue is very simple. We have tracked and demonstrated how the banks systematically violated hundreds and hundreds of years of well-established law, LAW. We further talk about how the judicial system, for a period of time, for the past 4, 5, 6 years, effectively had manufactured its own lore, L-O-R-E, by not following the law, not following rules of civil procedure, not following rules of evidence that have been the fabric and foundation of our system from day one to protect constitutional property rights and due process rights and make sure that the judicial system maintained its integrity. And we track that whole process, and we explain how tens of thousands of times in the state of Florida, courts ended up on the wrong side of this issue. What's interesting is really just in the past maybe 6 months or a year, we're seeing time and again, both in bankruptcy courts around the United States, in New Jersey, in New York, in Ohio, and in other courts, even here in Florida, and in Massachusetts particularly, we are seeing the courts finally understanding that the banks created a systemic crisis that literally cratered the entire economy. So what does this mean? It means two things. Number one, it's becoming very evident that the folks who are demonstrating against Wall Street understand that there's something fundamentally wrong with our nation and our polity. And that one of those issues is clearly that these banks have run amok, that they're too big to be governed, they're too big to be regulated. And like in the history of the United States, when you want to protect your capitalist fabric, what you need to do is break up these companies so that they can, in fact, continue to compete and maintain the fabric of a capitalist economy. The other issue is that these banks are so big that they have unduly influenced the government process so that they are now too big to be governed and too big to be regulated, and that is why they themselves must be broken up. Finally, what does it mean for you, the homeowner? Very, very simple. It means you're not to walk away from a foreclosure. You are to get competent legal counsel, and you are to make sure that if you have a securitized trust, that you defend your constitutional property rights. We believe that there are legitimate issues now in play every single day in Florida and throughout the United States concerning these issues. So I implore each of you, if you're in foreclosure, if you're considering a strategic default, to pick up the phone, either call our firm or some other firm, and get good, competent legal advice. Please feel free to visit our website, oppenheimlaw.com. That's oppenheimlaw.com, where you can read the executive summary of the law review article, or if you have nothing better to do, you're more than welcome to read the entire article, including its 180 footnotes, and we'd love to hear from you. Again, Roy Oppenheim from the trenches. Thank you very much.